Okay. Welcome everyone tonight to our webinar with Mr. Brad Wright. It's a real privilege to have Brad here today talking all about the medico-legal situation. And we're going to ask Brad lots of different questions that I think are relevant to you as dentists out there. And obviously we would like your questions as well towards the end. But to start off with, Brad, why don't you introduce yourself and explain a bit about your background?
Sure, Jeff. Well, thanks for asking me to have a chat with your group. Yeah, look, I graduated as a dentist in 1982, and I worked as a GP until 2007, pretty much, a little bit after that. But I did law in my 30s, and then after leaving and selling my practice in 2007, decided it would be good to do something different. So I went to the bar in end of 2010, early 2011. So yeah, I was a dentist for most of my working life. I'm still registered, but I work full-time as counsel in Brisbane or across Australia, but really I'm based in Brisbane. And most of my work as I get older, unfortunately, whether I like it or not, is dental related. So although I do some family law, some child protection, some administrative, some commercial and employment law, most of it is dentally related. So that's the background to why I guess I'm talking about this matter, because it's a fair part of what I do for work each day or week.
Okay, fantastic. Brad, the first question I really want to ask you is twofold. What do you see as the areas of practice that really get dentists into the most trouble with AHPRA or the Dental Council of New South Wales? And could you explain what the difference between those two bodies are?
Yeah, there's each state, in 2010, the national law was passed in each state. It's a replication of a Queensland Act, which is a health practitioner law act in Queensland, and every state introduced its own version of it pursuant to some Commonwealth legislation. When that was introduced, some of the states, not surprisingly, had a different view about how it might work. So although the Act is substantially the same across all states, it's significantly different in New South Wales and Queensland, less different in the other states. So to answer your question, the reason that I mention, or you mention, or we mention the Dental Council is because in New South Wales, it's co-regulatory, which means that the Dental Board exists nationally and it exercises jurisdiction through committees in each state. However, in New South Wales, because of the law, there is a separate dental council in New South Wales, which has the same, essentially almost all the powers that the Dental Board of Australia has in relation to New South Wales practitioners. So there are some differences in law between New South Wales and the other states, and there's certainly, respectfully, a difference in how that law is applied in New South Wales as to other jurisdictions.
Okay. So what do you see as the areas of practice that really get dentists into trouble with AHPRA or the Dental Council of New South Wales?
I guess the things that I see, because when people typically have an issue with a complaint, they'll go to their insurer or their regulator, who's I should say their insurer or their indemnifier, and there's 5 or 6 indemnifiers, and they all either deal with it by way of a dental peer or a dentist who works for them, or maybe not a dentist who works from them, but someone who initially assesses a complaint. So people only come to me if they're dissatisfied with their indemnifier and their attitude, and that is not an everyday occurrence, but it's not an infrequent occurrence. But what I see as the big areas and the things that I tend to appear in tribunals or to assist people with their responses to AHPRA or the Dental Council tend to be orthodontics, takes up a great proportion of it, implant-related prosthodontics and implant surgery, and probably otherwise prosthodontics. So they would be the big disciplines that form, not surprisingly, the biggest area of challenge for practitioners. And they, underneath each of those areas, there's obviously issues of consent, clinical records, patient communication, professionalism, all of those things come under those various areas. But to answer your question succinctly, I think it's probably orthodontics and implants.
Oral surgery doesn't play a big part nowadays?
It doesn't. I think because the number of extractions, well, extractions of wisdom teeth, which is probably what you're referring to, Jeff, you and I being of a similar vintage, wisdom teeth extractions were what people of Jeff's and my age, if I could be so presumptuous to say, was a very big part of our education, because that was the classic negligence claim, where someone was had paresthesia as a result of surgery. Certainly, there are oral surgical negligence claims, which are different to the regulatory matters. So, for example, there's a number of very famous oral surgeons across the country who have their names in Superior Court and High Court decisions, and I'm not going to name them here, but you don't have to look very far to find them. And that is unusual. They're public because they've gone all the way to a hearing in a court and appeal, but generally, most issues of complaint never get to tribunals and hearings. They are generally dealt with by way of settlement in the civil cases, and we'll talk about that soon, I think, and by way of AHPRA or the Dental Council making a decision, which unfortunately is not a decision of a tribunal, and they can be appealed, but they make decisions which do impose conditions on dentists' practices quite frequently.
Okay. A lot of people would ask, what's the difference between someone suing for negligence, or basically just someone answering a notification that comes from AHPRA?
They're two very different areas, and I suppose that this is not well understood, so it's probably worth spending a little bit of time on it. There are two separate strands of law, well, there's many, but in terms of dentistry and the things we have to be concerned about, patients, when they have a dispute or a complaint about a practitioner, they can do one of two things or both of two things. So the first thing that we talk about being sued is where someone brings a civil suit against a practitioner for negligence. And most dentists understand what negligence is, and that's obviously a duty of care standard which has been breached. There's been some damages which are caused by that negligence, and courts can, in certain circumstances, order that damages are paid for those losses because of the treatment. That's the civil law, and I am not a personal injury lawyer. I certainly did personal injuries for the first few years of practice, like many barristers do, but I no longer do. But I'm aware of the system, and the system is extremely different. Some of the terms used in the two jurisdictions are similar. You'll hear things like negligence, which equates to unsatisfactory professional performance. You'll hear about consent or informed consent, or what has mercifully recently been renamed valid consent, which it always should have been. But you hear about consent in both jurisdictions. You hear about negligence, which is like unprofessional conduct. But one exists to compensate patients, and that is the civil liability area, and the other exists to protect patients. So the civil liability is based on common law and jurisdiction acts in each state, I should say, legislation in each state. And they regulate how claims for damages are made. Now, that is completely separate to the second, which is the regulatory phase, which is what people are aware of, and that's AHPRA, Dental Council. Patient makes a notification. The Dental Council or AHPRA or the Dental Board or people involved in that process assess the complaint and decide whether it's necessary to take any action to protect the public. Now, if you've listened to all of that and don't understand it and haven't fallen asleep, what often happens is people will make a claim for one or the other, and typically they'll make a complaint to AHPRA if their lawyers understand the issues well, and that isn't always the case. They would make a claim to AHPRA, get an adverse finding by AHPRA, and then use that to build the civil case. So the two can run side by side, and I've certainly been involved in matters that have run as both regulatory and civil at the same time. But it's important for dentists to understand civil outcome means someone will be ordered to pay money to someone, meaning that one insurer pays for the treatment for a patient. A regulatory matter, and generally that's not publicised. Generally they settle out of court. They're not anything that is a matter of public record. They actually, unfortunately, normally settle on the day of the hearing, which is another matter. Regulatory matters can't settle, or very rarely settle, because the regulator has to make a conscious decision to protect the public, and they do that by way of cautions, reprimands, by way of imposing conditions, in rare cases suspending practitioners, and in extremely rare cases striking people off or cancelling their registration. But that's exceedingly rare.
Right.
So,
Okay.
yeah. So what I'm trying to say about that is dentists need to be more concerned about the regulator than they are to be concerned about being sued for negligence, because negligence is mandatorily covered by your indemnity insurance, and ultimately someone's going to pay some money to someone, and that's about all that really dentists should be concerned about, in my view. Obviously, it's important not to be negligent, but in terms of outcomes, it's a much lesser outcome than the regulatory matters.
And that's usually covered for by their insurer, I would imagine.
Yes, in terms of indemnity in the civil matters, generally that is the old system that existed, where there was 2 or 3 operators back in the 90s and early 2000s. Now there's a number of operators, a large number of new ones that are just becoming known of. For example, Berkshire Hathaway, which is the Warren Buffett insurance company, I'm aware that they are now operating in Australia as brokers and insurers. So there's a lot of competition in that area. So all indemnifiers will cover for indemnity as in a payment for an event. Some insurers and some indemnifiers do a better job than others in doing that. Of course, it's just the way humans operate. But also some insurers and indemnifiers do a better job of managing AHPRA investigations and notifications than others. But most insurers and indemnifiers, their policies include coverage, for want of a better term, for regulatory investigations and notifications, and also for civil claims. So if people understand that difference, then that's very important, because I think that most practitioners don't.
Yeah. So insurers actually cover the costs for the regulatory action as well, do they?
Yes, there's a principle of subrogation, which means that if an insurer is acting for someone, then to some degree, particularly in the indemnity phase, if we call it the civil liability phase, they will decide what happens. So they will take instructions, but ultimately they've covered the risk and they'll decide whether to pay it out or have a fight. In regulatory matters, that still occurs to a degree, but if there's a notification, the indemnifiers and insurers tend to get instructions from the client, the dentist, and they act on those to the degree that they can afford to. And so, but in broad terms, that's correct, that if you have a notification made against you, if someone were to, not you, Jeff, obviously, then in those circumstances, your indemnifier would cover you for the majority of the response to the regulator and some of those pre-litigation phases.
Okay, I actually never knew that.
And lots of people don't, because they don't know that they can go to their indemnifier, and that's what they pay the premiums for. Yeah. Sometimes they're dissatisfied with that and they go elsewhere, whether it's to me or other people, but they do, and they should always inform their indemnifier or insurer, because if they don't and they take action that may prejudice the claim later on, then they may lose insurance or coverage to the extent that their actions prejudice the later matter. So by way of an example, someone gets a claim against them, the dentist in the regulatory aspect writes a whole lot of material that inflame the situation, doesn't accept that anything's true, the regulator may take certain action, then the dentist turns to the indemnifier and says, oh, look, I replied to this myself, this is the response that I got, and the indemnifier says, well, we wouldn't have taken that action, we would have advised you differently, so we're not going to cover you further for any involvement in future matters in relation to this claim. So I'm not saying that happens all the time, but that's just by way of an example which what does occur.
That's scary. Is that the only way that they won't pay out, or they won't indemnify you? In other words, are there any clauses in your indemnity insurance where they could actually back out of paying for a claim?
Generally not. I mean, I think that insurers in general don't like paying claims because that's how they make money. I've seen, in my experience, I've seen very few times when people won't be paid. I've seen insurers threaten to do it, and I've heard them in, I'm not going to name names, do a lot of tub thumping. But I think because reputation is critically important, that they are loath to actually not cover someone for these sort of matters. There is the case that I can think of where someone was not covered, and that if someone has their registration suspended, so the various levels are conditions imposed, which might be education or something else. Suspension means that the practitioner's behaviour is such that they think that they need to take immediate action and stop the practitioner from working. If someone is suspended, they immediately cease to be members of the Dental Association under most jurisdictions, certainly in Queensland, and I'm sure they are in others. And therefore, their insurance is suspended also. So I've had at least one case where a person was suspended, and even though they'd been paying for a long time, and their insurer essentially said, "You're suspended, we can't help you." And that was mercifully turned around through some quick action, and but the insurer's attitude was less than ideal, I would say.
Okay, well, that's interesting. So how can a dentist prevent these notifications from occurring?
Well, I think most notifications occur because people are unhappy, and people who are unhappy for a variety of reasons. Generally, it's because of a poor clinical outcome, it's because of poor communication, it's because of a cost that wasn't expected, invalid financial consent. All of these things are triggers for patients to make a complaint, because let's face it, in any given day as professionals, whether it's me as counsel, Jeff, you as an orthodontist, or any other of the listeners, we all do things which are less than ideal. I'll put my hand up and say that we're not perfect. So everyone as a professional is able to be, no doubt, has aspects of their performance which is unsatisfactory to some people. Notwithstanding that, just because you do something wrong doesn't mean that you are going to be the subject of some negative outcome, because clearly sometimes people do things which are explicable, or they're one-offs and the damage isn't great, or it was an accident, it was not intentional. There's a whole range of reasons. So there are wording within all of the professional acts, including the Legal Profession Act in Queensland, and even the National Health Practitioner Law, which says that it must be performance that is substantially below that would be expected of a practitioner. So if, for example, Jeff, to use an example, you were, and I'm no orthodontist as you well know, but if you were to treatment plan someone and put on a bracket in such a way as the treatment was delayed, arguably delayed by a period of time, or some aesthetic outcome that was less than perfect in the short term, that may be unsatisfactory, but it's not substantially unsatisfactory, and therefore most regulators would look at a singular isolated incident as being not material and not worth protecting the public about. So, and I'm going to answer the question eventually, Jeff, but the question is, if someone were to do something which is not of the standard required, as long as that does not mean that there is a risk to the public, then the regulator is not going to act. So getting a notification is completely different to having to respond to one. So you can get a complaint made and it can be thrown out at the early phase. And AHPRA are very keen on saying that this is what happens to most of them. And that may well be true. But certainly if there's any hint of some substantial departure from normal standards, then they will investigate or assess, and they can impose conditions. So getting back to your actual question, Jeff, apart from my explanation for a long period, I think that the best way to prevent notifications are to have good communications and to act within the limits of your scope of practice. And by that, I don't mean the currently contentious dental board issue of scope of practice for people. And it's not actually, that whole issue currently in everyone's mind is not about scope of practice. It's about supervision and professional relationships. But if we're talking about dentists, they need to work within their abilities. So where I see big problems is where people work outside their capability. So for example, most dentists would be capable of doing a single crown on an anterior or a posterior tooth. I think we'd all accept that. Many dentists are capable of doing 3 and 4 unit bridges on patients' upper and lower arches. Some dentists are capable of doing single implant surgery and restoring that aesthetically, perhaps not in the premaxillary area, but perhaps in posteriors. But lots of dentists think, by way of an example in terms of implants, which seems to be where I'm going at the moment, that they can, if they can do 1 implant, then they can do 8. And if they can do 8, they can do 16. And that's where it all breaks down, is when people, dentists, exceed their capabilities and don't follow the accepted science that supports that treatment modality. In orthodontics, to give an example, it's arguable that even though most of us were educated by orthodontists who didn't want us to know anything, and I don't think that's contentious as general dentists, if one was to do complex fixed orthodontics without a comprehensive workup and understanding of why that is being done, then that is a problem. And that's why these 2 areas are complex and create problems, because people get out of their depth very quickly. And if a patient's unhappy, and I guess this comes back to expectations, if the patient's expectations aren't met, then, and they're paying a lot of money, then they're likely to make a complaint. So lower patient expectations, work within your scope of practice, get proper financial and consent in general, and these issues are far less likely to happen.
Okay. Out of interest, is there a difference between the standard of care that AHPRA would determine from a specialist to a general dentist?
That's a really good question, and I think I kind of know the answer, and I probably should know better. I think it does depend on the jurisdiction, but I'll probably answer it this way. If I am a dentist who's been graduated for 3 years and I'm doing orthodontics, I would have thought that, and I think the law is clear, that the expectation is not that I'm going to perform that to the same level as someone with, for example, your experience, Jeff, or qualifications, but I'd be expected to work within my scope of practice, my experience range, and to a similar level to a similarly experienced and qualified dentist. So it tends to be that it is a dentist. If I were, let's say, a dentist 3 years out, and I was doing orthodontics, and it was probably similar to what other dentists would do with that experience, meaning within a very narrow range of treatments, then that's unlikely to be the standard to be other than that. However, if one has been a dentist for a long time and done a significant amount of orthodontic treatment particularly, then you are more likely to be judged by people, specialists or otherwise, with a similar range of experience. So the longer you do things, the more likely it is that you'll be judged to the specialist standard, because ultimately the patients don't know what your abilities are. They're trusting you to go ahead. And if you sort of walk and talk like an orthodontist, but you don't actually treat people like that, then only if there's a problem or a notification, you might have a problem.
Right at the end, that'll bring me to a question. Actually, I'll ask it now, because one of the things that I find quite disheartening with some of my clients, like you would have had too, is that, you know, if they go to AHPRA, that for some reason it's always orthodontists, and they know, these orthodontists who are looking at this case know that it's a general dentist, which I think is very unfair. Personally, I think they should be told it's an orthodontist treating the patient.
So if I understand your question correctly, or commentary, whatever we're doing, you're saying that if someone makes a complaint to AHPRA and an independent opinion is sought in relation to that, then the independent reviewing, presumably specialist, should not be informed whether the person is a general practitioner or not. Is that correct?
That's how I would like. That's how I would like it to be totally unbiased.
I think that that is an ideal situation, but sometimes that is practiced in a way that makes it very clear from the clinical notes and the records that they are not orthodontists.
Yep.
But it could be the case that certain, and I have seen this in a matter I was in recently where the orthodontist giving the opinion, it was not disclosed to that person whether the person was a generalist or not.
Oh, good. Good.
But I think that's far and away unusual.
Okay, yeah.
I agree. But of course, orthodontics is unique, and we'll perhaps get onto that shortly, but orthodontics is unique because it is a specialty in the public's eyes. It's the only specialty that patients actually know about. Everyone who's a specialist is an orthodontist, apparently. And orthodontists, with the greatest respect and perhaps present company accepted, have generally acted to perpetuate the fact that only orthodontists can do orthodontics.
Exactly.
And as time goes by, there is a schism between the two branches of the profession, and there are a lot of people, including yourself, Jeff, and you're not alone. There's at least 4 or 5 other practitioners that I can now go to and say, look, this bloke's in trouble or this lady's in trouble. Will you be happy to have a look and supervise? And there are a number of practitioners, specialist orthodontists, even members of the AOS, who've said, is it AOS or ASO?
ASO.
ASO.
Yeah.
Who are prepared to say, well, you know, notwithstanding this, I'm prepared to do the right thing. But it is problematic because there is this professional issue, and it continues to be a problem.
Yeah, I totally agree. Yeah, and it really isn't very great professionalism from one colleague to another.
It's not, but again, and this is not your question, but just by way of an example, or just, and maybe some of your listeners may want to comment or ask a question about it, but there's a lot of unhappiness with practitioners about this smile direct, and people who go and get impressions taken themselves and get some clear aligners made, which ostensibly are not done by a dentist, but are sort of self-help. I'm talking this about the right way that makes sense to your listeners.
Yeah, do-it-yourself orthodontics, yep.
Yeah. And orthodontists, understandably, and I think justifiably, have a grizzle and a moan about it because they have concerns about public safety, and I think that's a fair point.
Yep.
General practitioners whinge and moan about it because they say the same thing, although sometimes they say it's about competition and patient safety. But the issue I have with all of that, and maybe I've got it wrong, but some of the orthodontic matters that I've seen before boards, tribunals and councils, practitioners do general practice orthodontics through a variety, and I'm not going to name any of the ways they do their education, through courses that are typically run by people who aren't orthodontists. That doesn't mean they don't know what they're talking about, but they run them through generalist organisations. And they actually delegate the treatment planning and diagnosis to a person who may or may not be in this country. So, and when they get before boards and councils, if they can't explain the reason for the treatment planning and the diagnosis, and it's clear that this was done by a third person in another country, or even a person who is not actually in contact with the patient, then justifiably the board or council believes this amounts to unprofessional conduct because people are really farming their work out and the responsibility of someone else. So that begs the question, what's the difference between someone taking their own impressions and sending it to someone to dictate treatment, and a dentist taking the impressions and sending it to someone else to dictate the treatment? Now, some people may say nothing apart from $3,000.
Yep.
But there is that issue, and I think that if I could get this across to your listeners who do general practitioner orthodontics, and look, I did for a while because the local orthodontist I didn't think was very good at that time, and there were some things that needed to be done and people couldn't get it done. However, and I don't think I'm alone in saying that orthodontists often used to say, I'll do the full mouth, or I won't do 1 or 2 teeth. I won't move that single tooth for you. That's a long time ago. So
yeah, unfortunately it's still there. today.
Yeah.
Yeah.
Well, it's unfortunate because that was what drove some practitioners to do orthodontics. It certainly was the case with me, and very limited, very, very limited. But the local orthodontists, over the years, there was a number of them, were reluctant to get in and do something simple to help out an aesthetic outcome if someone was seeking a pre-prosthetic thing. I've completely lost my train of thought there, but you might be able to help me, Jeff. But that's the issue that I see, that people need to be able to explain why they're doing it, what the examination, diagnosis, treatment planning, thought process is, because if that's been sent off to a computer somewhere in the United States and it comes back as a printout, then that's not a good thing.
Yeah, and I think that's a really valid point. There really isn't a great deal of difference from a do-it-yourself or the Smile Club Direct, and doing the same with even aligner companies, where you send it off and the aligner company does everything and you press the button and you approve the case and it doesn't work properly.
I mean, there is a big difference to the extent that the dentist doing that is going to be responsible for it, whereas the aligner company will probably escape liability unless someone's prepared to sue them.
Absolutely.
But I do think that the question has to be asked, what's the difference? And that's the reason why, once clear aligners came out in this incremental phase of doing treatment, which does not require a high level of technical skill, even a washed up old dentist like me could probably do it, then that really begs a question, answers a question as to why it's happening. And that's because orthodontics, to a degree, has had the lower levels of its treatment subsumed by technology. And you can't have it both ways.
Well, it's interesting is we've been doing a survey of all the clients who enroll in our course, and we say, "Are you doing orthodontics?" And they all go, "Yes." And what orthodontics? And it's all aligner therapy, but it still misses out on the diagnosis and the treatment planning, and it's an end result without going through the whole process of what you need to do for that patient. So you're still missing out on all the other factors, which is what you need to know.
Yeah.
So how can a dentist defend these notifications? They get a notification. How do they defend it?
Well, the first thing is that they should immediately contact their indemnifier insurer, and whether that's ADA VB or ADAQ or ADA New South Wales, whichever state, they need to contact their professional association and their insurer, indemnifier, and ask them if they can get assistance with it, because dentists are not very good at doing this on their own. They tend to be emotional. They seem to look at irrelevant considerations, and they often dig big holes for themselves early on. So first thing is, don't do it yourself. You've got insurance, and that's what it's there for, to give you assistance. It's also important to know, when you're doing these things, or when your indemnifier is writing things for you, that you understand the audience. So, for example, there will be an audience initially, which will be dentists who will be sitting on a council or a registration committee. So there are a number of dentists, 5 or 6. Actually, that's not true. 3 or 4, plus a couple of lay people that sit on these committees, and they interpret the data. So when you're writing a response to a notification, you're writing it for 3 dentists and probably 2 lay people to interpret. And unfortunately, dentists write that and don't understand that. And also, with the greatest respect to some of my legal colleagues, they don't understand that either. You really have to know your audience and who you're writing to and why. So in the first instance, a notification is going to demand a response. That response should be done within time. Initially, it's usually asking for records. Then after that, there'll be an opportunity for submissions. Don't do it on your own. Get some assistance and do it in a timely and respectful way. That's the first thing. The second thing, which is really stepping back a bit, is getting to the point that you actually have good clinical records and an appropriate, well thought through, evidenced consent process. So, for example, if the clinical records look like they're written by a 16-year-old texting their friends, which is what a lot of clinical records look like, then that is not going to make a decision maker particularly enamored of that approach. So if you've got good clinical records, whoever the decision maker is or reviewer of these records will tend to take a more favourable view if it's legible, understandable, written in plain English, and meets the guidelines, the Dental Board of Australia guideline on dental records. And thirdly, I guess, and I'm coming back to these points again and again, Jeff, because they are important, and that is to get consent, financial consent, consent to the nature of the treatment being done, and give people warnings. And absolutely critically for orthodontic practitioners, have the right of referral to a specialist available at all times. So it's absolutely a problem if practitioners do treatment and they don't provide a referral opportunity to an orthodontist, because people need to be told that it's a generalist doing the work and that a referral is a possibility. So they're the things that I think are critical.
I'm glad you said that, because one of the things that we do with our clients is give them an informed consent form for the different types of options. And one of the first paragraph is, we are general dentists we're not specialist orthodontists. Because, because I think you've got to be very transparent, because my feeling is, if they're not happy with that, let them go now.
Yeah,
you don't want to treat every patient, that's for sure.
No, absolutely you can't. And I remember what I was going to say before about orthodontics. People do practice orthodontics because they can't get what they want. I was saying before about where I lived many years ago. If orthodontists won't do what you want, then you're perfectly free to, as a practitioner, to do the orthodontics yourself. And if it is something that's within the scope of practice that you were taught at university, like a removal appliance, or you've done some training in clear aligners, that's fine. But it's really problematic to go on beyond that, because whenever push comes to shove, obviously there's different schools of thought of how orthodontics should be done and treated, but you'll be judged by the conservative orthodontic profession rather than what your friends in the study club who also have done the same course may think.
I think that's a really valid point, is that you're going to be judged by the conservative people. So, you know, to go out there on a limb with some of these systems, you know, is fraught with danger, as we know.
Yeah. And look, it's fine, because obviously some people believe that airways and other issues are important. Others think that airways are not. Some orthodontists still put, as I understand it, circumferential banding on lower sixes and, in fact, in great parts of people's mouths. That's a very conservative way of doing orthodontics. And if you don't want to do that, or you don't want your patients to have that, that's fine. But you need to be able to explain your thinking process and why you're doing it in that certain way. So, as I said, in my personal circumstances, conservative orthodontics, I should withdraw what I said earlier about not very good. It wasn't very good for my patients to have conservative orthodontics, to go and have to have a full mouth of orthodontics when they could have just had something simple.
And the same applies today. So, you know, in fact, even more so today. You know, because there's so many better cosmetic options when you've got to change the size and the shape of the teeth and all that you can do orthodontics, you know, for pre-restorative work.
Well, people are very high expectations about what needs to be done.
Yeah.
I mean, I've had orthodontics done twice, so I'm probably rare. Full mouth orthodontics done 2 occasions. One when I was, I guess, 14 to 16 in Brisbane. Bob Rippleman was the orthodontist, or he wasn't even an orthodontist. Jeff, you may well know the Rippleman story.
No, I don't know him. He was before
anyway,
my time.
He was I thought you might say that. He was a generalist who did orthodontics, but he was the only person that was doing it in those days. And I went to him as a child in Brisbane, into the T&G building, for anyone who comes from Queensland. And the practice is there. I think it's still Rick Olive's practice. I think it might even be now, or it was Rick's. I think he sold out. But in any event, went there. For some reason, I didn't have extractions done. Still got my 32 teeth. They were done, progressively relapsed over time. Got sick of it and had some, again, not that you would know, I'm no better looking or anything since, but I had them redone by a very good practitioner who's still a friend and colleague. So I've been through it twice, and I know the limitations, because it's very temporary unless it's retained. And it's something that does take a long time sometimes, and people are impatient. So if they can get it done with clear aligners in what seems to be a short time, then great.
Absolutely, absolutely.
But if they can't, you can't keep on using something that's not going to work. And I'm not giving clinical advice. I'm just making that observation.
And there are great risks associated with having braces on twice or three times as well. Root resorption, all these other factors that it's too late. It's too late at the end of the day.
Yeah, absolutely. It's and people need, if I can get across to viewers, listeners, people need, it's about the patient and the patient's right to choose.
Yep.
And if you obviate or vitiate that right to choose by doing things that you think are right without the patient's ability to say so, then you are ultimately likely at risk. And so high risk procedures currently, like implants and orthodontics, then I think there might be significant paperwork so that people understand.
Yep.
And significant high level communication, effective communication about it. And if that's not done, then it certainly can be a problem.
Well, that's like the joke, what's the difference between God and an orthodontist?
I use that all the time. I tell it against all sorts of professions, but you're right.
Absolutely. But I think that's the most appropriate one in dentistry.
Yeah.
Okay. So I think we probably covered how can a dentist better practice informed consent. I think we probably covered that.
Yeah, I mean, I think that what people need to do is they need to turn their mind to what the patient might need to understand and know. Have some, and I'm happy to send it to you, Jeff, I haven't already, just a checklist that you go through. So you make sure that consent has been gained, valid consent, but ultimately consent is not a decision for the dentist to make, it's in the patient's mind. So a patient is the person who decides whether they've consented, whether it's valid consent or not. To the broader picture of what's being done is really a question usually for a third party, being either a regulator or a court. So all you want to do is to cover off and make sure that you've done everything necessary. I was watching, when I was on holidays recently, we were in a country where there's not a lot of English spoken, and we found House on television, which we somehow had, my wife's an RN, and somehow we never watched House in its entire run. So now we're wading through it. But there was one episode which I thought was very good in relation to consent, and it was a complex neurological, physiological issue they were trying to explain to, as they always do in that show, after a lumbar puncture and multiple MRIs and all the other things. But what the doctor, Foreman, who's the African-American doctor, said, I don't think that we can get you to consent because it's far too complex for you to understand. No matter how long we spent on it, you wouldn't understand. Now, I think that's an important point to think about, but I don't think it's our role to tell people that they can't. You just have to keep on, in dentistry at least, giving them the opportunity to understand, because the important difference between House and orthodontic practice is that no one's going to die from not having orthodontics. I mean, a few orthodontist kids may not go to private school, but no one's going to die. Whereas that's what people don't understand. You can't take that parallel from emergency medicine across, because there's a therapeutic privilege in consent from Rogers and Whittaker in 1992, which I'm sure everyone's read. And basically, there's an emergency therapeutic privilege, and that is that if by giving people information, it would likely give them a worse outcome in your estimation, then you're free not to give them that information. Now, that's how you get around it in emergencies, but there's no such circumstance in dentistry, or so rare it's not even worth talking about. It's arguable, for example, that if you told every patient who had a nerve block that there was a 1 in, and I used to know the number, 1 in 76,000 chance they get profound and permanent paresthesia from the inferior dental block, many patients wouldn't have an inferior dental block.
Yeah.
And the outcomes for them more generally would be more adverse. Now, I'm not saying that you don't talk to people about adverse outcomes with ID blocks, but it's by way of an example that you can imagine how that might start to look like a therapeutic privilege. However, if the patient asks you the question, you've got to answer it.
Yep, sure.
Not lie. But I do think it's important that people do understand that the emergency privileges and the lack of onus to get consent applies in exigent, urgent situations, not in general.
So are you saying that, do we have to go through and explain really rare situations?
I think
just the more common?
Well, I think what it's about, and it's something that dentists aren't always very good at, is you have to, consent is not about telling, it's about listening. So, for example, giving information is what dentists and I dare say the people listening to this might do. But what patients want to do is be listened to. And so if you're listening to what they're saying and asking them questions, for example, do you have any concerns? Do you understand what I'm saying? If you were to go numb, would this be a concern for you? That's very different to saying, and listening to that response and then going back again. That can take a matter of minutes.
Yeah.
But that's very different to what passes for consent. And that is giving a very long form and asking for people to sign the bottom of it and saying, right, job done, because that's not what it's about. So the reason I'm saying that, Jeff, is because if you actually ask patients questions and build on those questions, then two things will happen. One, you will have a very good knowledge of whether the patient understands what you're doing. And secondly, that builds a relationship between you and the patient that makes them know that you're concerned about them and you're actually thinking about the outcome. So it cuts both ways. It's both preventive in the sense of stopping people making a complaint, and it's also effective because it helps document the consent process.
Okay. So basically what you're saying, that for them just to sign the informed consent is really not really informed consent from a legal point.
It's absolutely not. And look, maybe this is the first time we all agree we're never going to use the word informed consent. The reason we shouldn't use informed consent is a Californian term. It was specifically disavowed in the High Court in Rogers and Whittaker and has been since on at least one occasion. It's the wrong term. The term is valid consent, because informed consent carries a whole lot of negligence issues from America, which I think would be well advised to avoid. So, and valid consent means that was a consent given validly. And, you know, a good example of valid consent, which was, you know, a paper I read recently, wasn't a paper, it was a report, but a psychiatrist was explaining to someone as to why, if, I think it was a psychologist in this case, a psychologist had a sexual relationship with a patient. Probably didn't see this coming, but here we go. And the psychologist was explaining as to why that was tantamount to rape or a lack of consent, because of the professional relationship between the patients, that patient and a psychiatrist or psychologist, I think it was. Consent can never be given by the patient because the professional disparity of power imbalance, I should say, is so great that consent can never occur because they're not in a position to give that consent. Now, if you use that parallel to something perhaps less salacious in dentistry, where we're saying to someone, you should have this procedure done, then unless the patient understands, which is the same as the power imbalance issue, then they can't consent to it because they didn't understand it. And if they don't understand it, they can't consent. It's simple as that. And I think that practitioners would do well to, next time they're trying to get valid consent, because we're declaring informed consent illegal from this point on, they would do well to think, well, does the patient understand? And if you're struggling with that, what you should do is try and warn people so much that they don't have the procedure done. And if there's a balance between selling and warning.
Yep. So
on one hand, you've got the selling pressure, and one you've got the warning pressure. It's a matter of professional judgment as to where you sit on that continuum. more cautious practitioners will probably never have invalid consent alleged as against them, because they're constantly warning, warning, warning. And if the patient has it done, well, that's a great outcome. But the ones that are selling are not warning enough, and they are the ones who are at greater risk of invalid consent being alleged as against them. Does that help?
It sounds to me, and I may be misinterpreting it, but this is just opens up such a can of worms from a legal point of view, because the patient can just about say at any time, if there's been a dispute, I haven't had valid consent, I didn't understand.
And that view of the patient or expression of their position won't always be accepted, because if you've got documentation that evidences a long discussion, opportunity to ask questions, information given, you know, you're going to defeat that allegation. And most people are reasonable and don't lie.
Yep.
Most people do understand. But, you know, by way of example, and I posted something on that GPR forum the other day, that doing veneers on people is a really good example, on virgin teeth is a really good example of the issues of valid consent, because it's irreversible, it's completely destructive, it's going to have long-term outcomes that are of morbidity in terms of teeth survivability, and patients just generally don't understand. And so we have a duty to explain to them. And if we explain to them to the point that they either give up and say no, that's not a bad thing. If we explain to the point that they say, yeah, I think I've got all that, is there anything else I should know about? And then you tell them anything else, you know, you don't have to go to the 1 in 300,000 chance issue. You have to hit the big ones, like, you know, and I think it's always good to say to people, start off with, if this were my tooth, this is what I would do, or if this was my dentition, because that's got a ring of truth about it. And if you're honest, you're probably not going to go too far wrong.
Yeah, that's great advice. I think you've discussed already that orthodontics is a bit of a special case here.
Yeah, I think it is, because of the reasons that there's the schism between the professionals and not. And what I would say about that is, your consent processes need to be like a specialist is, and your clinical records, meaning the way that they're recorded, but equally the quality of the records. So photographic records have to be the way that orthodontists do them. Study models have to be taken and recorded the way orthodontists do. Radiography needs to be done that way, because if it looks like you've just thrown it all together and sent it off to a lab overseas, then that's how it's going to be viewed. So I think that because of the nature of orthodontic practice and how orthodontists generally are, and they're the people who are going to be judging you, then you need to comply with that fairly narrow range and high expectations.
Yeah, I must admit, that's one thing that over the last, I think, 20 years, orthodontists have done quite well, is taking good records in general.
To the point of obsession, some people would say. But
yeah.
I've seen, when I worked at UQ, I saw how much time postgrads were spending on polishing models with soap and lining them up with micrometers, so I understand.
Yeah, I think we've gone past that stage, but at least good photographic records. Yeah, and now we've got scans, and we've got digital files, and there really should be no excuse for not getting perfect records.
Yep.
I couldn't agree more. So what issues arise in relation to action against general dentists doing orthodontics? Because I'm sure the people, my clients would be are worried about what actions do take place.
Well, I think most of them have been covered, but perhaps to go through them in order of likelihood. I mean, the first thing patients say is, I thought that X was an orthodontist. So that's easily dealt with by execution of a document by the patient saying, I understand that X is not an orthodontist. The second thing they say is, I wasn't given an opportunity to be seen by an orthodontist, and that's easily dealt with by insisting and including on the same form they have a right to see an orthodontist at any time of referral at any point in treatment. And thirdly, have a think about the treatment that you're doing and whether that is, in all the circumstances and availability, that is the best treatment. So if you're going to do extensive treatment and surgery might be a consideration, then consider surgery and refer them off. don't just say, I mentioned surgery to them and they said no. That's not the same as giving them a positive referral to an orthodontist or a maxillofacial surgical team to assess them and tell them about the outcomes.
Yep.
And probably thirdly is a fundamental lack of understanding of the mechanics. And I am not someone who has that understanding, because I was educated by a well-known orthodontist in Queensland to a degree many years ago. And so my view would be, if you expect that at some point you're going to have to defend the decisions you make in treatment, and it needs to be evidenced by proper clinical journals, evidence-based reasons to do your treatment, rather than something that someone told you was a good idea. So they tend to be the issues. Length of treatment, where treatment goes on much longer than it should have, because people sometimes get out of their depth and keep on going when they should be stopping and getting advice or referring off, because we all get out of our depth. There's nothing wrong with that. But it's better to be honest with the patient about it and explain why.
In fact, that's the only problem about being a specialist, that we've got nobody to refer to.
Well, yeah, as you know, I'm only being facetious, but people do refer to other specialists. And one of the duties as a professional is to talk to other practitioners. And that doesn't mean post an anonymous post on Facebook. That means pick up a phone, meet someone, take some records and have a discussion. I mean, there is a contextual quality aspect to face-to-face communication, particularly this is better than telephone, which is better than social media. But there is nothing like sitting down and talking to someone.
Absolutely. Yeah, agreed. We're running a bit late, so we'll just finish off with the last couple of questions. Can dentists really practice orthodontics today, or really anything, I think, without being worried about the regulator?
I think that if the basics are done, which is really clinical records, understanding the consent process. And look, if people struggle with consent, when I was a law student in the 90s, mid-90s, I did a thesis on informed consent, or what was then called informed consent. And I still struggle at times. And I think I understand it as well as anyone. Maybe I'm not very bright or not articulating it very well, but it is difficult.
Yeah.
But I think that if people are unsure, then you need to warn and warn and warn and warn. And at some point, both you and the patient will be exhausted and someone will make a decision.
Yep.
And the more you sell, the more you're at risk.
Yeah,
but I do think clinical records are generally awful that I see. And consent processes are rudimentary. They're form signing rather than a discussion. And people say, well, how do you evidence that? Well, you ask a question, you get a response. You have a perfectly trained, hopefully touch typist dental assistant typing in a conversation. You have evidence of the warnings that you've given in writing, and there's an opportunity for the patient to discuss it. Now, if you, and I know that you were sort of a bit incredulous before, Jeff, and I'm sure the listeners are as well. Well, if I do all that, the patient can still say they didn't give valid consent. But if you do all those things, it's very hard for them to deny that they understood and had an opportunity to understand and ask questions. So it has to be recorded. And I think that if people do that consent process properly, then patients go, they relax, they understand, and therefore they're less likely to complain or have an issue.
Perfect. Okay. And the last question that I've got for you, Brad, is how will the dentist know if the insurer isn't really taking them seriously?
Well, most do, because it's their job and it's in their interest to. But I know you and I are aware of a couple of cases where the insurer's just rolling the arm over. So if you have a complaint as a dentist and the insurer says, well, you fill in a response and we'll have a look at it for you, that may well be enough. But if you consider that it's not being, the attention to detail isn't there and there's aspects that aren't addressed in the response, then you need to get advice. And I don't mean necessarily from someone like myself, but you need to talk to other practitioners. And probably the point I'm trying to get across is everyone gets complaints. I've had one as a dentist 8 years after an event which was dismissed. I had one as a barrister which was dismissed. no one likes it, but it's a fact of life, and there should be no embarrassment about talking about the issue with someone else apart from the complainant and your peer advisor.
Yep.
The peer advisors will have a number of cases on at a time, and there's only so much time and resources they can devote to it. And sometimes people have big enough problems, and this is to a degree self-serving, that the only thing they can do is go to someone who can devote a number of hours or days to a matter to resolve it for them. But I do think it's important to speak to someone. Don't take it all on your own shoulders. Talk to someone, ring me up until I get bored and hang up. But I'm happy to talk to people, or at least refer them to someone, or tell them to talk to another practitioner who might help them. But you don't have to deal with it on your own.
Out of interest, because I'm assuming the ADA in all the other states, I know in Victoria we have, I can't remember what they're called, but like liaison officers who usually deal with a lot of the complaints before they escalate. And personally, I've been happy, probably 50. I've had a few complaints as well. 50% I've been happy with. The other 50% I haven't been happy with.
Well, sometimes that's personality and understanding, and sometimes you'll get a different person, and sometimes it's because they're busy, and they can't turn their mind to it or don't care. I mean, whenever I get a complaint, even if I just talk to someone on the phone, when I say get a complaint, when I get someone asking me, I always try and think about it as what would I do if it were me. And I think that's what most peer advisors will do. But they're not lawyers. They're certainly not counsel. They certainly don't have advocacy experience and even the experience with the area. There are some very, very experienced peer advisors across the country who I have a great deal of respect for. And there are some that aren't in that category. And there are a lot of people who are lawyers who do this work, and they don't understand the issues. So, if the hairs come up on the back of your neck and you think it's not right, it probably isn't. So have a talk to someone.
I think that's great advice. Brad, we've gone for over an hour. It's been absolutely fascinating. Let's open it up for some questions from other people. They're probably wanting to have dinner though, so let's just...
I do want to have dinner, but if there's any questions, I'll do my best. And if there's not, that's okay too. They can always ask you later and email them to me, and I'll do my best to respond. But if there's anything now...
They can email me, I can send them off to you. Send them off to you. Because I'm not seeing any questions, but that could be because I really don't know how to use the question answer. We've got a question. Okay. No, we've got a comment from Benita. Thanks, Brad and Jeff. That was very informative. Thanks, Benita. I think that was an understatement. That was, seriously, I learned so much in that hour, and I thought I knew a little bit about this. It was just great. We would love to have you back again. I would love to do a presentation with you one day, because I know you do a lot of presenting. I think that'd be just fantastic.
Well, not anymore. I'm sort of semi-retired from that. I still do it occasionally. I'm still thinking about doing a consent program at some point, but I'm sure we'll talk about that.
I think you should, because you've got so much information, and honestly, you will save people so much heartache. Because
that's the aim. It's dentistry is stressful enough, as I recall it. It's without this on top of you, you can do without it. But it's a long road to get good clinical records and a good consent process, but it can be done.
Look, I think your information is absolutely fantastic. I really would love to see you out on the lecture circuit. I know it's so busy for you, but it would just be great for your knowledge to be imparted, and save people the stress factor. Because I know the clients that we've dealt with together, it is a very, very stressful situation for them. Even if they've done nothing which is wrong, it changes their whole life.
That's right. And look, if people should feel encouraged that they should reach out, because it's just it's just too terrible to go through if you don't have someone to speak to. But look, I'm happy. I hope that there's a question there. I hope that people have learned something, and it's all honest information. That's for sure.
We've got one last question from Remo. Is it ethical to offer the option of a referral to a specialist when you don't believe it's in the best interest of the patient in a particular case?
Well, that's an excellent question, Doctor. How do you pronounce that?
Finelli.
Yeah. Remo, the answer to that, I think, is it? I'd go back and say to you, is it in the best interests of the patient? That's a decision that you or the particular dentist might make. So I think that if you thought, for example, when I was talking before about practitioners who are going to be very conservative, there would be nothing wrong with saying to the patient, look, I'm happy for you to see someone else, to go and see an orthodontist, but they're going to have a very conservative attitude to this. And I don't know that that's in your interest, because a conservative outcome will be X, Y, and Z. I think that's appropriate, but I don't think that you can not refer them because you've prejudged. I think you have to have a conversation with them, but you'll flavour that in the way that you want to indicate what your view is. But I think that it might be ethical when we're talking about legal, which is not the same, as everyone well knows, but it's probably ethical not to do it, but it may well be not unlawful, but unprofessional not to give them the option, even though there may be a practitioner who is so conservative in their treatment that you think it might be not appropriate for the patient. But let them decide, and they're intelligent. They can take on board what you'll do, and they may well not take that referral.
Brad, I can't thank you enough for your time. That was really just a sensational hour, and I really look forward to hearing more from you at some later date.
Okay, thanks, Jeff. Good night, everyone, and Remo. See ya.
And Brad, thank you so much for your time. That was really fantastic. We really appreciate it.
Thank you. Good night.
Have a great night and enjoy your dinner.
Thank you. Cheers.
Okay, thanks,
Bye.
Brad. See you later. Bye.